Dear friends, welcome back. This is episode number 102 of CPC. In episode number 101, that is the last episode, I cited a decision in Muhammad versus Moideen Haji, AER 2000 Kerala 329, about the ritual called Kutuba in Juma mosques belonging to Muslims. I said about the background. Then I will read 2 or 3 head notes because that is enough, and also paragraph 2. One of the head notes: dispute as to whether religious discourse called Kutuba in a mosque in connection with the Juma prayer on Friday can also be in vernacular along with its essential ingredients in Arabic. Suit is maintainable since it is a matter affecting the right to worship. The freedom guaranteed under Article 25, that is of the Constitution, to practice religion is exercised primarily with religious worship, ritual and observation, and religious practices are as much as part of religion as religious faith or doctrine. That is paragraph 2. Paragraph 2 I will read. Then another heading: Kutuba meaning of. What is Kutuba? Ingredients of Kutuba. I just the heading. The literal meaning of Kutuba is speech. There will be an assemblage for Juma prayer and the Imam will be delivering the speech to such assemblage. Imam, in some parts it say Khatib. The Imam will be standing on the pulpit, that is Mimbra, while delivering Kutuba. Though in literal sense Kutuba means speech. Being a speech in connection with a religious affair, it should conform to certain essential standards. Kutuba is conducted in 2 segments. There are 2 parts in it. In between them, the Imam will sit on the pulpit, Mimbra. The Kutuba is conducted not only in Juma prayer but in connection with Eid prayers and even on the occasion of marriage, which is not considered to be a prayer. Kutuba is also performed at the meet of Arafah during Hajj time. The famous speech delivered by the Prophet, known to be his last speech, was that delivered in a meet at Arafah in connection with Hajj pilgrimage. Then next, another paragraph, head note: conducting of Kutuba during Juma prayer in a mosque on Friday can be in Malayalam, local language, after observing the essentials in Arabic. Even if the Kutuba is considered to be a part of the prayer, it will not lead to a conclusion that no Malayalam can be used in Kutuba, as in this case, in the case of Namaz. Now I will read paragraph 2. The respondents have contended as a preliminary objection that the suit itself is not maintainable as these religious matters do not create any enforceable right to anyone and therefore cannot be adjudicated as a dispute of civil nature. See the contention. A very senior lawyer, he has argued. One of the best lawyer the Kerala High Court has ever seen, Mr. T.R. T.R.G. Warrior. He put forward this argument. Suit itself is not maintainable as these religious matters do not create any enforceable right to anyone and therefore cannot be adjudicated as a dispute of civil nature. So the suit itself was not maintainable. In the light of the decision of the Supreme Court in Most Reverend PMA Metropolitan and others versus Moran Marthoma, that is 1995 Supreme Court AER 2001, this being a matter affecting the right of worship will certainly affect the civil right of the parties and is therefore a dispute of civil nature. Though on the merits of it regarding Kutuba, whether it can be in Malayalam or in Arabic alone, that was decided in favor of the respondents. But this point was in favor of the appellants, said that the suit is maintainable. The right to worship according to one's belief is a right available to any individual and therefore if the manner in which such right is exercised is interfered with by another person or group, necessarily it will give rise to a dispute of civil nature, which can be adjudicated by a civil court by entertaining a suit. As held by the Supreme Court in the aforesaid case, that is Moranmar Basalios, the expression civil nature used in section 9 CPC is wider than even civil proceedings and extends to such religious matters which have civil consequence. It was further held by the Supreme Court that, quote, the civil courts have jurisdiction to entertain suits for violation of fundamental rights under Article 25 and 26 of the Constitution of India, unquote. The freedom guaranteed in Article 25 to practice religion is exercised primarily with religious worship. See, the freedom guaranteed under Article 25 to practice religion is exercised primarily with religious worship. Ritual and observation and religious practices are as much part of religion as religious faith or doctrine. Therefore, the finding of the lower appellate court that the suit as framed was maintainable cannot be said to be incorrect. That finding is upheld and the preliminary objection raised by the respondents' defendants is overruled. See, this is the case. So, Kutuba case is a unique case. Definitely you must read it. And this is a worship affecting this among the Muslims. So, you must know what is Kutuba. When in North India, when I travel to various places, judicial academies, I cite this when section 9 is dealt with. I cite this decision and ask even the Muslim judicial officers, do you know what is Kutuba? They said that they did not know, except one or two. That is the fate of the younger generation. That is, they do not. But in our state it is quite different. The younger generation, not educated, even less educated class, they are very much aware of all these things. Yes, next is AER 1985 Supreme Court 577. Parallel citation 1985 to SEC 54. Abdullah bin Ali and others versus Galappa and others. Galappa and others. Section 9, jurisdiction of the civil code. Allegations made in the plaint decide the forum. Jurisdiction does not depend on the defense taken by the defendants. Jurisdiction depends on the allegations in the plaint. Paragraph 5, 6 and 7 are relevant. The jurisdiction does not depend upon the defense taken by the defendants in writing in the written statement. On a reading of the plaint as a whole, it is evident that the plaintiff's appellants have filed the suit giving rise to the present appeal, treating the defendants as trespassers as they denied the title of the plaintiff's appellants. Now, a suit against a trespasser would lie only in the civil court and not in the revenue court. The High Court, however, took the view that the plaintiff's appellants had not claimed a declaration of title over the disputed plots, and all that has been set up by them in the plaint is the relationship of landlord and tenant. This High Court decision was set aside. In our opinion, the High Court was not quite correct in observing that the suit was filed by the plaintiff's appellants on the basis of the relationship of landlord and tenant. Indeed, when the defendants denied the title of the plaintiffs, so it was a pakka title suit. the plaintiffs asserted title, the defendants denied it. Indeed, when the defendants denied the title of the plaintiffs and the tenancy, the plaintiffs filed the present suit, treating them to be trespassers, and the suit is not on the basis of the relationship of landlord and tenant between the parties. It is no doubt true that the plaintiffs had alleged that defendant number 2 was a tenant, but on the denial of tenancy and the title of the plaintiffs' appellants, they filed a suit treating the defendant to be a trespasser. And a suit against a trespasser would lie only in the civil court and not in the revenue court. Plaintiff stated about the tenancy, but the defendant denied that relationship and said that he is not a tenant. And then who else is he, according to the plaintiff, when he has title? He claims that he has title. Then the question of proof of title, whether the plaintiff has proved the title, then the suit will be decided. It is a pakka suit on title. Then if the plaintiff says that he is the title holder and the defendant is a tenant, the defendant denies that relationship, then his position is that of a trespasser, is according to the plaintiff. We are therefore of the considered opinion that on the allegations made in the plaint, the suit was cognizable by the civil court and the High Court has erred in law in not suiting the plaintiffs on the ground that the civil court has no jurisdiction. So in this context, it was held that the allegations made in the plaint and not the defense taken in the written statement, that matters in deciding whether section 9 is applicable, the bar of section 9 will apply. Next is 2005 10 SEC 760. Parallel citation AER 2005 Supreme Court 2544. Church of North India versus Lavaji Bhai, Ratanji Bhai and others. What is held is that when the plaint read as a whole does not disclose material facts giving rise to a cause of action, which can be entertained by a civil court, the plaint can be rejected under Order 7, Rule 11. And in paragraph 39, it was held. A plea of bar to jurisdiction of a civil court must be considered having regard to the contentions raised in the plaint. Here again, it is reiterated by the Supreme Court. For the said purpose, averments disclosing cause of action and the relief sought for therein must be considered in their entirety. The court may not be justified in determining the question one way or the other, only having regard to the reliefs claimed, dehors the factual averments made in the plaint. The rules of pleadings postulate that a plaint must contain material facts. When the plaint read as a whole does not disclose material facts, giving rise to a cause of action, which can be entertained by a civil court, it may be rejected in terms of Order 7, Rule 11. So it is here also it is reiterated that what is the allegations and averments in the plaint alone constitute the jurisdictional factor and not what is contended by the defendant in the defense. Then Dhulabai's case I cited, Constitution Bench decision. It is very, very, very important. And the passage which I cited from Premier Automobiles, 1975 Supreme Court case, that contains the basic principle that when a common law right or liability is recognized in a special statute, then unless there is a bar to the jurisdiction of the civil court in the special statute, the jurisdiction of the civil court is optional at the instance of the suitor. On the other hand, when there is a bar in the special statute, then other questions whether the reliefs are sufficient, whether the principles of natural justice and other things are violated and all those things. That is an area different. Where the right is a new right under the special statute, and a remedy is also provided, forum is also provided, then and there is a bar of jurisdiction of the civil court, it is certain that the civil court will not have jurisdiction. In the same set of circumstances, if there is no bar, then the court will consider the question whether it is a self-contained act. If it is a self-contained one, the civil court's jurisdiction is impliedly barred. This is the fundamental thing which you have to bear in mind while approaching Section 9, because that is a very foundation of the starting of the case. So we have to be certain about, on facts and in the circumstance of each case, it may pose a difficult question sometimes. Yes, next case is 1997 5 SEC 460, parallel citation AER 1997 Supreme Court 3082. Vankamidi, VANKAMAMIDI, Venkata Subbarao versus Chatlappalli, Sida Rama Ratna Ranganayakamma, Sida Rama Ratna Ranganayakamma. Must be from Andhra Pradesh. Land forms laws. It is held that the civil courts, the jurisdiction of the civil court stand excluded. Paragraph 15. Reference is made to a 1991 Supreme Court judgment. Then further down, long paragraphs are there. Very long paragraphs. Paragraph 15. 15 is a very long paragraph. I have marked it for reading, but because of paucity of time. Thus, it could be seen that the civil court cannot unsettle the pata, which has become final in the decree now passed pursuant to the declaration. So, the rule of construction being that every presumption should be made in favor of the existence of a right and remedy in a democratic setup governed by the rule of law. And jurisdiction of the civil court is assumed. The exclusion would therefore normally be an exception. Courts generally construe the provision strictly when the jurisdiction of the civil court is claimed to be excluded. Then further down, it is settled legal position that if a tribunal with limited jurisdiction cannot assume jurisdiction and decide for itself the dispute conclusively, in such a situation, it is the court that is required to decide whether the tribunal with limited jurisdiction has correctly assumed jurisdiction and decided the dispute within its limit, etc., etc. Statutory tribunals. Therefore, each case requires examination whether the statute provides rights and remedies and whether the scheme of the act is the procedure provided will be conclusive and thereby excludes the jurisdiction of the civil court in respect thereof. That is in one of the categories of cases which is referred to in Premier Automobiles case, that 1915 case which is referred to there. Then in one place it is said that after the advent of independence, the history, the land forms was one of the policies of the government abolishing feudal system of land tenures and conferment of rightuary pata on the tiller of the soil. Thereby the land forms laws extinguish pre-existing rights and create new rights under the Act. The Act confers jurisdiction on the tribunals in matters relating to thereto, and hierarchy of appeals revisions are provided thereunder. giving finality to the orders passed thereunder. Thereby, by necessary implication, the jurisdiction of the civil court, therefore, by necessary implication, the jurisdiction of the civil court to take cognizance of suits of a civil nature covered under the land reform laws stands excluded, even if there is no express bar. If it is a self-contained statute and a right is created and a forum is also provided for the first time, then even if there is no bar of jurisdiction of the civil court, it will be impliedly barred. Under the normal course of civil procedure, the jurisdiction of the trial of the civil suits in relation to matters covered under the acts being time consuming and tardy, that is the requirement of land reforms legislations and ouster of jurisdiction of the civil court. Thus, para 16, thus it could be seen that the civil court cannot unsettle the pata which has become final in the decree now passed pursuant to the declaration. So, in almost every land reforms legislation, there is an ouster clause ousting the jurisdiction of the civil court and conferring jurisdiction on special tribunals. There is appellate jurisdiction, there is revisional jurisdiction. And therefore, it is a complete code, and it cannot be said that there is no opportunity for the litigant to put forward his case, and an appeal is also provided, revision is also provided in most of the rent control, most of the land reforms legislations. You may also see explanation 8 to section 11. That is also relevant here. An issue heard and finally decided by a court of limited jurisdiction, competent to decide such issue, shall operate as res judicata in a subsequent suit, notwithstanding that such court of limited jurisdiction was not competent to try the suit or subsequent suit or the suit in which such issue was subsequently raised. I will explain it while dealing with section 11, but please note that if a court of limited jurisdiction, there the expression used is court, but it was held by various courts that it includes tribunals. A tribunal constituted under a special statute confers exclusive jurisdiction on that tribunal, and a limited question of tenancy is decided by that tribunal, it becomes res judicata. In our state also it was held so in 1978, and later in 1979 the land reforms law was amended, and it was specifically provided therein that section 11 CPC will apply. Yes, we will see in the next episode. Thank you.